Thank you so much for joining us today for our webinar on moving from a visa to a green card. My name is Dustin Saldarriaga, and I'm a senior associate with Scott Legal PC. Joining me today will be our partner, LeGrand Weiner, who has extensive experience helping clients navigate the non-immigrant visa process, the green card process, and between the two. So we're very fortunate to have her expertise on today's presentation. A few things before we get started. This webinar is part of a series. We try to do several of these a month, and they are on a variety of immigration topics. So we do hope that you will tune in for future webinars. We'll be sending an email after this webinar with a link where you can sign up for those future webinars. As I mentioned, our firm does handle the full spectrum of U.S. immigration. So though today's webinar is on business immigration primarily, although we will touch on family-based immigration, our firm does handle the full spectrum. So regardless of whether your question is regarding family-based immigration, business, employment-based immigration, or humanitarian-based immigration, please do reach out to us for assistance. We'd be happy to help. That email that you'll receive after our presentation today will also have a link to our YouTube channel. We will be recording this presentation, this webinar, and we do post the full-length webinar to our YouTube channel as well as shorter videos, and those are on, again, a variety of immigration topics. So do check out our YouTube channel. We'll also share with you the PowerPoint presentation that you see on your screen. So no need to take notes if you're just copying down the PowerPoint presentation. We will be trying to get through all of the questions we receive during today's presentation. I may save those for the end of the presentation, but we do expect to get through all of them by the end. So if you have a question, send it in either through the chat function or the Q&A function on Zoom, and I will be monitoring those throughout the presentation. All right, without further ado, I will go ahead and pass it off to my colleague, Kelly.
Thank you, Dustin. Perfect. So let's take a little bit of time just to talk about how the green card system works, in particular in relation to family-based green cards and employment-based green cards. So essentially, there are kind of different categories within each of these options, and we'll kind of explore a few of them. So under family-based green cards, either you can, file as an immediate relative. So this is where if there's a U.S. citizen who wants to sponsor their spouse, their children, their parents, these are the immediate relatives of U.S. citizens. Or if a child who is 21 or older wants to sponsor their parents, their child must be a U.S. citizen. These are immediate relative categories, and there's a lot of benefits that you get from filing under an immediate relative category. A main one being that there is always a green card available. So for the preference categories that we'll talk about, there is delays in whether or not you can, file your green card application versus, let's say you're here. You're a U.S. citizen, you marry someone maybe from Canada, you want to apply for their green card, you can do so right away. There's never going to be a delay with that. If you do apply under, what we call a preference category, then sometimes there are delays. And, right now, every category under the family preference categories is delayed. So what that means is that you can file what's called an I-130, which is a petition for, your relative to come get a green card, but then you can't do the actual green card step of the process until later, until your priority date becomes what we call current. So that means that let's say when you file your I-130, you file it today, your priority date is June 25th, 2024. But you're not able to file your actual green card application, until a later time. So if you are in a preference category, that's for either unmarried, sons and daughters of U.S. citizens who are adults, spouses, children, and unmarried sons and daughters of legal permanent residents, so green card holders, married sons and daughters of U.S. citizens, and brothers and sisters of adult U.S. citizens. So these are the, preference categories for family-based green cards. So we'll talk a little bit about employment-based green cards, and we'll go into more detail on these later. But just to kind of talk about them very quickly, the EB1, has a few different subcategories, but one of them is extraordinary ability. So this is for people who have reached the very top of their field, achieved sustained national or international acclaim. There's the EB2. This is a very commonly used category for green cards through employment. Either you can self-petition using the national interest waiver, which we'll talk about the requirements in more detail later, or you can be sponsored for a green card through a company where a U.S. employer has hired you and they test the U.S. labor market to see if there's any U.S. workers who could do the job, and if not, they can go through the process to sponsor you for the green card. The EB3 is the same as the EB2 in the sense of company sponsorship. So that's the same process. If you're going to have a U.S. employer sponsor you, the EB3 doesn't have that subcategory that allows self-petitioning the way that the EB2 does. EB4, so this is a catch-all for many different types of green card categories, one of which is the religion-based green card, people who come on an R1 visa and transition to a green card. And then finally, there's the EB5. So this is an investor-based green card. This is where you're investing either $800,000 or $1,050,000 and creating 10 full-time jobs as a basis for getting your green card. All right. So for family-based green cards, I went over kind of what immediate relatives and preference categories are. Unfortunately, as I mentioned, there are backlogs for preference categories. So if you are in that process or you're interested in that process, a good resource to become familiar with is called the U.S. Visa Bulletin. So every month, the Department of State will issue kind of a new visa bulletin that explains, who can file for their green cards, at what point can you file. So, for some categories, for example, brothers and sisters of, adult, U.S. citizens, of adult U.S. citizens, that category is backlogged, worldwide to, 2007. So that means that only people with a priority date of 2007 or earlier are able to go ahead and file, for their green card applications. Additionally, it's important on the visa bulletin to understand that where you were born will impact potentially, when you're able to file your green card application. So it's not a matter of where you hold a passport, but where were you actually born? And that is where, that's where on the visa bulletin, you'll see there's certain, countries that are specifically listed, for example, mainland China, India, Mexico, the Philippines, where there are kind of different backlogs applicable to people who are born in these countries because there has been so much immigration from those countries that, the way that the immigration system is set up, where it only allows a certain percentage of people born in certain countries to immigrate, it does mean, unfortunately, there are longer backlogs, for people depending on where they were born. Excuse me. In terms of the actual process for applying for a green card through family-based process, that can be done in one of two ways. So either, maybe you file an I-130, that first step that proves the family relationship. And then when you're ready for the green card, you're going to consular process. So that's where if you're living outside the United States, your application gets sent to a U.S. consulate in that country. You'll attend a medical exam, you'll submit biographical documents, and then you'll attend an interview at the consulate. And if your application is approved, they'll put an immigrant visa in your passport. You'll enter the United States on that visa while it's still valid. It's usually valid for 6 months. And then your green card is mailed to you once you're in the United States. Another option is called adjustment of status. So this is where, let's say you're already living in the United States, or you're here, on a valid status that allows you to adjust. Then you would go ahead and you can file, the I-485. Sometimes you can concurrently file the I-130 and the I-485. So for example, in an immediate relative case where there's always an immigrant visa available, you can go ahead and concurrently file. And then if you were in a situation where any of the preference categories were current, for a while, the category for spouses of green card holders was current, they were able to concurrently file as well. So you always want to check the visa bulletin. If you're in the United States and you're going through an adjustment of status, you're also going to file for employment and travel authorization when you file for your green card. These can permit you to kind of work and travel while you wait for your ultimate green card to be approved. All right, let's move back to discuss a few of the employment-based categories, particularly the EB-1A. So as I mentioned, the EB-1A is for people who have, achieved sustained national or international acclaim and, have risen to the very top of their field. So generally, the requirements are either that you have achieved like one, large achievement such as a Nobel Prize, a Pulitzer Prize, or much more commonly, you're going to qualify by showing you meet at least three of the following that are listed here. So these, are all aimed at, proof that you are somebody who has risen to the very top of your field. So are you a member of associations that require outstanding achievements of their members? Is there published material about you or your work in major publications in your industry or major media generally? Have you been asked to judge the work of others? Have you made any major original contributions to your field that are of major significance? Any scholarly articles that you've authored? Any places that your work has been displayed? Evidence of leading or critical roles in distinguished organizations, a high salary, success in the performing arts. So the EB-1A encompasses business, athletics, arts, so all of that is all encompassed under the EB-1A. So anybody who's qualifying based on being, extraordinary in their field, this is going to be the category they'll use. Some benefits to it. So you can self-petition. For many of the green card categories, you need a sponsor, either an employer, or a family member. But under the EB-1A, you can self-petition. It is a good option potentially for entrepreneurs because the normal EB-2, EB-3, perm process where a company sponsors somebody is not good for, it doesn't really work for entrepreneurs because during the perm process, you have to disclose whether there's any ownership in the company. And the government just doesn't believe that if you own a company 100%, that you're really, testing the labor market in good faith to find somebody else for your job. So functionally for entrepreneurs, the perm process doesn't really work. So the EB-1A or the EB-2 NIW, we'll talk about in a minute, can be great options for entrepreneurs. So this is a two-step process to apply. So the forms you're going to file are one, the I-140, and then the I-485 green card application if you're in the United States, or you can go through consular processing. So the structure is similar, to the family base that we just talked about, where there's going to be one initial petition. For the I-140, it's going to be the petition that demonstrates you have this extraordinary ability that shows all the evidence we've talked about above. And then, if the category is current, you can go ahead and proceed with the green card application part of the process. All right, so for the national interest waiver, this can be another great option for entrepreneurs and also people who, are interested in self-petitioning, who maybe don't have, a U.S. employer. To meet this criteria, though, you do need to be, have an endeavor in your mind that is relatively developed. So in order to qualify for the national interest waiver, you must be working on an endeavor that has substantial merit and national importance. You yourself have to be well positioned to advance that endeavor. And then on balance, it has to be beneficial to the US to waive the normal requirement of the labor market test. In order to get an EB-2 initially, you have to show you have an advanced degree or exceptional ability. Advanced degree means either a master's degree or higher, or the equivalent. So an equivalent would be a bachelor's degree plus 5 years of post-baccalaureate progressive work experience. If you don't have the educational background, you can also try to qualify based on exceptional ability. That's a standard that's a bit lower than extraordinary ability, so it can be a bit easier to meet, but you do still need to show that you meet at least 3 of the 7 criteria. And it is, so again, this is a category where I think sometimes people will assume, well, I have my master's degree, and I work in, finance, so can I qualify? So the answer to that is, not without more, right? There has to be, again, like the main thing for the EB-2 NIW is what is your endeavor? Why does it have substantial merit and national importance? The government has released some very helpful, kind of guidance in policy manuals and also a critical and emerging technologies list, all of which are meant to help people understand, what are the types of endeavors the government is going to consider important. And if you're working on those endeavors, it may be a good option for you to pursue the EB-2 NIW. And again, this is very favorable for entrepreneurs because let's say you've started a successful business, but you can't go through the perm process. Your company's doing really well. It's, making great strides. It's got lots of employees. It's doing great things in the industry that you have other experts that are willing to comment on that. That can be a great launching off point for an EB2 NIW, petition. Again, it is something where it's not really for people that are just, I'm going to have my company and it's going to be a great company and do what it does. You want the company to have that tie-in. It needs to be able to show what about it has substantial merit? What about it has national importance to the United States? Are you improving technology in a particular area? Are you improving competitiveness for the US in an industry that's, important to the United States? These are the types of things to keep in mind. All right, let's talk about company sponsorship. So this is done through the EB2 and EB3, what we call the PERM process. This is, I'd say, a very, commonly known process where maybe somebody comes to the United States, maybe they go to university here, they get an H-1B, and then the next step is to ask their company or have their company sponsor them, for a green card through the PERM process. So this does require a U.S. employer. You cannot self-petition as you would with the EB1A or the EB2 NIW. In terms of the process, there's three main parts. So the first is the PERM, and within that first part, there are a lot of, sub parts, and that whole process itself, the PERM, can take 2 to 3 years. One of the reasons it takes so long right now is that when you file the PERM, that in itself is taking over a year to be approved. So we're seeing some extremely long processing times from the Department of Labor. At this moment in time, they have said not to expect any significant change anytime soon. So right now, this is kind of the timeline that we're seeing, a few years for that first step. Once you get to the second step, you file the I-140 petition. That can be premium processed. And then the last step is the green card. Let's talk a little bit more about the sub parts of the PERM. So if you're going to go through the PERM process, your company will really be driving that first part. So that's really where the US company is responsible. They're going to file for a prevailing wage determination. That's where they ask the Department of Labor how much has to be paid for this job. The Department of Labor will return basically the minimum amount that has to be paid at the time that the person receives their green card. The company has to draft a job description that is what we call PERM compliant. So that means that instead of asking for kind of all the ideal traits you would want in an employee, really the company has to decide what is the minimum requirement to do this job in a reasonable manner. If I had to hire somebody tomorrow, what is the baseline requirements they would need? And that's what, you have to use for the PERM job description, because they want to make sure it's as open as possible to, US workers qualifying. Once they've drafted the job description, got the prevailing wage, they'll start the actual labor market test, also called the recruitment process. That's where the company is required to place advertisements. There's specific places they're required to put the advertisements, based on the regulations. If they make it through, it's a 60-day process. If you go through that process, and the employer is interviewing people, but they don't find anybody who is minimally qualified for the job, then you can go ahead and file the labor certification. Right now, the Department of Labor is taking about a year to process those. The case can either be certified, meaning approved, it can be denied, or it could be audited. And there's different triggers for audits. For example, let's say the job requires a foreign language, but it's not like a job for a Spanish teacher, or it's not a job where it's really obvious why a foreign language is required. Or if you're filing a case, for a more entry-level position, but the experience requirement is very high, it's outside what the Department of Labor considers normal, then the company is going to need to be, prepared to justify itself based on what is a business necessity for the company. So it can be good when you're going through this process to keep in mind, are there audit triggers in my file, and how can I, try to lessen those if possible. And in terms of timing, as I mentioned at the start, it is kind of right now kind of a 2 to 3 year process, partly because it's taking 6 to 7 months just to get the prevailing wage. It can be a couple months to get the job description together. The recruitment process itself is 2 to 3 months. And then the actual, processing of the labor certification is a year or more. And if it's audited, it can be a little bit longer than that. However, once you get through this long process, if you do get to the point where you can file the I-140, as I mentioned, you can premium process. Now you can get an answer within 15 business days. The green card part of the process, you do have to consider, is there a green card available in your category? So we're going back to the visa bulletin that we were talking about with the family-based categories. Is the category current or not? Unfortunately, there are backlogs right now across the board for employment-based, green cards. So it is important to check every month to see, what situation you're in, whether or not you need to consider if you're in the United States, do you need to extend your underlying status? If you're outside the United States, you need to be prepared to be out for a bit longer. If you have children, how old are they? Are they going to be able to be part of your green card process? Depending on how long of a wait there is. So it's all good things to keep in mind, when you're going through this process.
Great. We will now spend a little bit of time talking about the EB-5 green card option. The EB-5 is unique in some ways. It's called a job creation green card, and it is the green card option that Kelly mentioned before that is available based on your investment. So the required investment amount is either $800,000 or $1,050,000. That difference in investment amount depends on whether the business is located in what's called a targeted employment area, which generally means a rural area or an area of high unemployment. And the government actually created some additional categories, including infrastructure projects, that will also qualify for that lower investment amount. However, if you are starting a business, say in the middle of Manhattan, you are likely to not be in a targeted employment area. You would need to invest that $1,050,000 amount, the higher amount. There are two main pathways to an EB-5 green card, and those two are regional center or direct investment or standalone. So the regional center option is actually the most common route, and that's because essentially a regional center project is usually a very large project. It could be, say, a resort or a shopping center. We're talking projects that cost tens of millions, if not hundreds of millions of dollars, and therefore can support dozens of EB-5 investors. The regional center would register with the government, with USCIS, and then basically you as the EB-5 regional center applicant would be able to put your $800,000 investment amount into the regional center and qualify for the EB-5 that way. And the regional center would handle hiring, would handle a lot of the documentation. So the regional center pathway is really the passive option for an EB-5 green card. That fact, coupled with the fact that most regional centers are located in targeted employment areas, so therefore qualify for the lower investment amount, makes them a very attractive option for the EB-5. The other way to get an EB-5 that I mentioned is the direct investment, also called the standalone option. So what that is basically where you as the EB-5 investor run the business. You're an active manager of the EB-5 business. The example I like to use is a restaurant. Let's say that you are an entrepreneur, you enjoy running your own business, and you want to invest, let's say $800,000 into a business that you would run. You would need to be the only EB-5 investor. So if someone else wanted to join you as an EB-5 investor and also invest the $800,000 amount, you would have to register that as a regional center. So the direct investment option is only for one EB-5 investor. But if your goal is to actually run and grow your own business, that direct investment option may be attractive to you. Regarding the employment requirement, again, the EB-5 is called a job creation green card, which is very telling. At the end of the day, you do have to show the government that your investment led to the creation of 10 full-time jobs for U.S. workers, and that's U.S. citizens or green card holders. If you're investing through a regional center, you can use indirect job creation. So that means, let's say we're talking about a resort as an example. A resort is the regional center project. that resort might attract other businesses. Maybe there are little shops that are gonna be selling things at the resort. Maybe there are independent contractors who are going to get work as a result of the building of this resort, who are going to do construction, who are going to work on gardening, making the grounds attractive. In the regional center context, you can use indirect jobs like those to count toward the 10 required jobs per investor. In the direct investment context, you cannot use indirect jobs. You can only use direct jobs. So those are W-2 employees that your business directly creates. So again, going back to our restaurant example, the job requirement would have you investing the $800,000 or $1,050,000 amount. And then after that investment is made, creating 10 full-time jobs for those directly employed by your restaurant. So waiters, waitresses, chefs, line cooks, etc. So there are the second bullet, it says new commercial enterprise. That is the technical term for the business that you're investing in. In the regional center context, there may be a difference between the new commercial enterprise, the business, and the job creating enterprise, the actual entity that employs the people. That's a little bit in the weeds, but in the direct investment context, usually the new commercial enterprise is the entity that's actually creating the jobs. In the last couple of years, new regulations were passed regarding EB-5 for good reason. The program actually stalled for the regional center option for about 9 months. So Congress passed some new regulations. We actually have a separate webinar, full hour-long webinar on the EB-5 specifically. So if you do want to know more about the new regulations and just the EB-5 as an option, please do check out our YouTube channel where we have, again, that full length webinar. And we go into much more detail on what the new regulations are. What investment can be included? Fortunately, the government is quite flexible in terms of what investment can be included in the EB-5. Now, that being said, there are some very strict requirements. You do have to thoroughly document where you got the money from that you are investing into the project. So whether that's, again, 800,000 or $1,050,000, the government is going to want to see where every single dollar came from, and that you had personal possession of every single dollar. So to take an example, you are allowed, as your source of funds, to use a gift from a family member, to use a loan that's secured by your personal assets. But if you are receiving a gift, let's say you have a very generous parent who wants to give you $800,000 for your EB-5 green card, they need to transfer those funds to you personally. They cannot transfer those funds to the EB-5 project. Let's say they want to send the money directly to the regional center. That is not going to work. You need to personally hold the funds before you invest them into the EB-5 project. Similarly, if your source of funds is earnings from your business, let's say you have an E2 business that's very successful, and you decide that you want to use the earnings from that E2 business to pursue an EB-5. That is something that you can do. However, it's important that you not use retained earnings to qualify for the EB-5. You actually need to have those earnings distributed to you personally. You need to pay tax on those. It needs to be a bona fide distribution, so whatever documentation that would entail, to show that you actually received those funds personally, you paid taxes on them, and then you turned around and put them back into the business. That is critical. Timing is also important. So let's say, again, you have an E2 business and it employs 10 people. You take a distribution from that E2 company, and then you put that $1 million back into the E2 company, and now you say, I want to apply for an EB-5. You need to show that those 10 jobs were created after you made the investment. Again, it's important to show that your investment led to the creation of at least 10 full-time jobs for US workers. So timing is critical there. Investment has to happen, and then the creation of the 10 jobs has to happen after that. There are a number of differences between the E2 and the EB5. Again, if you're interested in this, do check out our longer webinars on the EB5 specifically, or schedule a consultation. We're happy to talk through this in more detail and specific to your circumstances, since the EB5 is a complex green card option. So it's helpful to have an attorney walking through it with you. But the key differences between the E2 and the EB5, the E2 is not a green card. The E2 is a temporary visa that, yes, you can renew indefinitely. However, it does not lead to citizenship, whereas an EB5 is explicitly for the purpose of you remaining in the US permanently. And if you ultimately decide to pursue citizenship once you have your green card, you can do that. Also, the investment amount is significantly larger for an EB5. An E2 does not have a set investment amount. We have seen investment amounts as low as, in some cases, depending on the circumstances, $20,000 to $30,000. Whereas the EB5 has a strict, at least $800,000 investment amount. And I'll quickly note that the $800,000 and $1,050,000 amount does not include administrative fees. So one of the new requirements that came about in the last couple of years is you not only need to show where the funds came from that you're investing into the business, but you also need to show where the funds came from that you're using to pay for administrative fees. So especially if you're going through the regional center option, there are typically significant administrative fees with that, usually in the realm of about $50,000. In the past, you didn't need to show where you got the money to pay those administrative fees. Now you do. So when you're thinking about, how do I account for my investment amount? Don't think only of that $800,000. Also think about those administrative fees. You do need to show where you got those fees and that you had personal control of those fees, those funds before you paid the fees. Some challenges for EB5 applications. Source of funds is going to be the key one. Showing where you got the money is usually the most difficult part of an EB5 application. Again, you have to trace every single dollar from the source to the EB5 investment. Another challenge is in the direct investment option. This doesn't come up really in the regional center context, but if you say, you know what, I want to be a business owner, I want to manage that business, and I actually want to buy an existing business, you can run into trouble if you save up your $800,000, you find someone who's selling their successful business, you send that person $800,000 and you have a business, but you don't have access to those $800,000 to create those jobs. If you are buying a business, it is important that your investment go into the business. So any funds that you send to the seller, who then owns those funds, they are the seller's funds to control and do what they want with, those funds aren't going to count toward your investment. So in contrast, if you are buying a business and the seller remains part owner, so your funds go into the business, and then you can deploy those funds to develop the business, buy inventory, market, hire workers, that can count. So your funds do need to lead to the creation of those jobs. So if you're making an equity investment, be careful of that. Job creation, as I mentioned, 10 full-time jobs need to be created per EB5 investor. And again, those need to follow from your investment amount. You don't need to have those positions created by the time you file your application. And that's key. You can apply for an EB5 green card based on a comprehensive business plan. You don't actually need to have created any jobs at the time that you file your EB5 application, as long as you have a comprehensive business plan that shows how you're going to create those jobs over typically a 2-year period following your application. So that can be a huge help to people who are applying for an EB5. Linkage to job creation, again, investment needs to be tied to the creation of jobs. The process of applying for an EB5, I will just say, tends to be time consuming. There are really 3 big steps to the process. Step 1 is filing what's called the I-526. That is basically letting USCIS know that you intend to apply for an EB-5. Here's how you will accomplish the investment requirement, the employment requirement. If the government approves the I-526, then you can apply for a conditional green card. And I say conditional because if you are approved, you basically will have this conditional green card for 2 years. And that 2-year period starts either when if you're within the US, your adjustment of status to a conditional permanent resident is granted, or if you're outside the US, the moment when you enter the US on the immigrant visa and receive conditional permanent resident status. So that's when the clock starts. You basically have 2 years from that point in conditional permanent resident status. At the end of that 2-year period, you're going to file an I-829. And that is an application to remove the conditions on your permanent resident status. So at that stage, that's when the government is going to look at how the business is doing. Have you invested the amount you're required to invest? Has that investment led to the creation of 10 jobs for US workers? If it hasn't, in many cases, you will be denied. There is some flexibility on certain aspects. So for example, if you haven't hired all the employees you need to hire, there is sometimes some flexibility there. You may be given more time, but in general, you really do want to hit the EB-5 requirements by the time you file the I-829, if at all possible. If the I-829 is approved, then you will have your unrestricted green card after that, and all the benefits that come with that. And then down the road, if you do decide to pursue citizenship, that is an option as well. I will say a couple things here on the process, which are really key. As I mentioned, this process generally takes a while. Just to give some context, USCIS in many cases will estimate the amount of time required for the I-526 at about 5 years. So 5 years for USCIS to decide the I-526. And again, that's step one. So our firm does have a practice where we sue the government because we do believe 5 years is unreasonable. We have had success in those lawsuits to get the government to move faster in its processing and adjudication of those applications. But do have in mind that the I-526 phase can take a number of years. And again, once that is approved, that's when you can apply for the conditional green card. That gives you 2 years in conditional permanent resident status. The I-829 is now being delayed. So we also have lawsuits against the government to speed up the processing of the I-829. But just know, going into this, the EB-5 is not a fast process by and large, and can take oftentimes between 5 and 7 years from start to finish. A couple things I'll say on that, though. After the new law was passed in the last couple of years, as I mentioned, there are some prioritized categories. So infrastructure, rural, high unemployment. The government has actually been adjudicating applications on a faster timeline, generally if they fall into those categories. So we have been hearing of I-526 applications being decided within a year now, in some cases, if you're applying on those in those prioritized categories, which is wonderful. But again, is not a guarantee and is not necessarily, certainly not going to apply to everyone. The final point I'll make on this is an enormous benefit that came with the enactment of the new EB-5 law a couple years ago, which is that you can now file concurrently the I-526 and the I-485 if you're within the US, and if, as Kelly mentioned, your green card is current. So what does that mean? If you look at the visa bulletin that Kelly mentioned, you'll see that the prioritized categories, so high unemployment, rural areas, infrastructure projects, there are a certain number of EB-5 visas reserved for those categories. And so there's not a backlog for them yet. So if you're in the United States and you were born in, say, India or China, there is the possibility of you applying for an EB-5 based on one of those priority categories. And again, most regional centers are going to fall into those categories. And if you do apply for one of those, you can file the I-526 and the I-45 at the same time, which means you can also apply for work authorization and travel authorization. Within a few months, you will have the ability to work in the US, the ability to travel while your EB-5 is pending. And the travel authorization and work authorization should continue through the duration of the EB-5 being pending. So that can be an enormous benefit. So do consider that, particularly if you were born in India or China. If you're outside the US, that's still relevant because you can apply at the consulate for the immigrant visa once the the visa is available according to the visa bulletin. So it's still a way to get around the significant backlogs that particularly affect those born in India and China. With that, I'll go ahead and pass it back to Kelly to talk about other green card options.
Thank you, Dustin. So we'll just briefly touch on some of these points. Different options available. One is the diversity visa lottery. If you are from a country that has kind of historically low rates of immigration to the United States, they'll publish a new list of countries each year. You can enter the diversity visa lottery to see if you're selected. If you are selected, then, you'll go back to the visa bulletin, you'll continue to check the visa bulletin because ultimately, if you were selected in that process and you want to go through it, your green card has to be granted before the end of the fiscal year. So the end of the fiscal year is September 30th. So for people who are selected in the diversity visa lottery, they're generally filing their applications, once their number becomes current. So when you get selected, you'll get a number related to your, the place that you are. They'll do, Europe, Africa, and you'll check the visa bulletin, every month to see when, your number allows you to file. And then once you do file, you generally need to ask, for an expedited processing because it does have to be granted before the end of the fiscal year. So just because you're selected in the diversity visa lottery does not mean you're guaranteed to get a green card. In fact, they know many people will not. So you do need to take those steps quickly to move through the process if you do want to get it that way. There are, other than employment and family, you can also get, green cards sometimes through different humanitarian relief options. So that is, something to consider as well. There's also special circumstance green cards. So, for example, if you get a U visa, something to do with, helping police with crime or something, related to that, often there's a pathway to eventually apply for a green card, although there can be waits, significant delays before one is available in that category. And then finally, there's always the possibility that there is immigration reform. It's unlikely at this current time. It seems unlikely for, perhaps the next few years at least as well. That being said, it is one avenue through which, changes can be made. There are executive actions that can be taken that are kind of separate from comprehensive immigration reform. So when we refer to that, we're really talking about kind of changes to the law that are passed through Congress. But there are also changes that can be made through executive actions. So there's, changes that have been made in the recent past, in June of this year, executive actions that have been announced. So there will be more coming on that, as they kind of, provide more details on how those programs will be rolled out. Other things to think about just when you're going through the process of a visa to a green card, so timing considerations. We've talked a lot today about the visa bulletin, and there's a reason for that. It's because it really does control, when you are going to be able to file for your green card application. So you do want to be thinking about that strategically. Are you trying to apply for a category where there's a backlog? If there is a backlog, how are you going to bridge that gap? With EB-5, there are something called set-asides that were, introduced where there is not a delay in those particular green card categories. So for, most people born in China and India, EB-5 is backlogged. However, if you are, if your investment is in one of these set aside categories, rural, high unemployment, or infrastructure, that those categories for green cards are current. Always want to be thinking about, the country specific quotas. Where were you born? That's what we call it chargeability. It means that's where you're charged to for purposes of determining is there a green card available. If you have a spouse and they were born in a different country, sometimes you can do something called cross chargeability. So that would be something you potentially want to discuss, with your attorney if you and your spouse were born in different places. Other things to think about during the green card process, what is your need for international travel? If you're here in the United States, what are your underlying kind of visa expiration dates? What are your goals? Does your family live here? Are you trying to kind of stay through the green card process, or would it be okay if you need to go back, to your home country or another country and spend some time there, before you get your green card? So these are all important things to think about. There are strategies you can use depending on what your particular situation is. You also want to think about if you're here in the US, do you have a dual intent visa if you're going through the green card process? If you're on an F1 as a student, and you have an approved, immigrant petition, that can be a much bigger issue than if you're here on an H-1B or an L. So it is significant what type of underlying visa you have and where you are in the green card process in terms of whether you'll be able to travel freely, whether you'll be able to renew your visa. All of those are important things to discuss. You can also think about parallel green card strategies. So there's nothing to say that somebody couldn't, kind of be pursuing an EB2 NIW, and then perhaps, they get some really big, kind of achievements or promotions in their career. Maybe they think, okay, I think now I'm an EB1A category. I think now I meet this criteria. You certainly can have, parallel green card strategies going on. Once you get to the stage of actually processing the green card, you should be, settled on which selection you're going with. But certainly, in the various categories, you could consider multiple ones, to see, EB1A is often less backlogged, than EB2 or EB3. And then, finally, I think, planning is really key here. You want to just think about if you're going to be trying to get a green card, often this can be a very long-term strategy. And, you want to move it to the United States permanently. You want to just be thinking about all these things we talked about today. What are your family needs? What are the considerations for work? Where do you want to be living? All of these things you want to take into account, as you're planning your process for getting your green card.
Great. Thank you, Kelly. So we have received one question during our presentation, a very important question to clarify. So the question is it true that an individual who gains a green card is not allowed to return to visit their home country for 5 years? So fortunately, that is not the requirement. You are allowed to travel, really, if you're within the US, once you have your travel permit. Once you have your green card, certainly you can travel into and out of the US. The requirement that you, I believe, are referring to with the question is that you do need to be very careful if you're planning to leave the US for a period that is 6 months or longer. Because the government may make the assumption that based on the length of your time outside the US, you intended to abandon your green card. So basically, travel into and out of the country. However, if you anticipate being outside the country for 6 months or longer, you really should talk with an attorney before you leave the country. And there are steps you can take. If you really don't have an option to make a shorter trip, which hopefully you do, that's the best thing to do. But if you really have to be outside the country for 6 months or longer, you can apply essentially for advance permission, or telling the government, I'm going to do this. My intention is not to abandon my permanent resident status. Approximately, what is the total cost of the process, including attorney's fees? I have a TN visa. So we don't discuss fees during our webinars, partially because we have a separate unit that handles billing, but please do reach out to our firm and we will share with you an engagement letter that details our process for applying for the EB-5 visa, as well as our fees. And another option you have is to schedule a consultation, which will give you a chance to share your specific circumstances, what your goals are, whether the EB-5 is a good fit, and that consultation will also give us a chance to better gauge how appropriate the EB-5 is for you. Can I apply for work authorization if I submit my EB-2 and IW 2 months before the end of my OPT? Kelly, I am going to ask you for your thoughts on this one. Can I apply for work
Sure.
authorization if I submit my EB-2 and IW 2 months before the end of my OPT?
So essentially, like the EB2 NIW has two parts. One is the I-140. So filing the I-140 doesn't give you any status in the US. It also doesn't give you any basis for filing for work authorization. The I-485, the second part of the EB2 NIW, that's the green card part. If you are able to file that, then you can file for work authorization when you file that. Unfortunately, like right now, the EB2 NIW is backlogged. So that means that you're not able to file the I-140 and the I-485 together. So essentially, you would have to file the I-140 first, and that does not give you the ability to apply for work authorization. So you're not able to apply for work authorization based on the EB2 NIW until you get to that green card stage of the process if you're here in the US and able to file an I-485, adjustment of status application.
Great. And then somewhat related to this other question that came in, which I think is getting at the idea of dual intent, and when you are in the US on a non-immigrant visa, how do you maintain that while the EB-2 is pending? But can I apply to another school? So presumably they're in F1 student status. Can I apply to another school after submitting my EB-2 and IW just to remain in status before my priority day?
So it is, certainly if you're going to be, if you have another school that you're going to and you're able to, like if you're on an F1, you're going to get a new I-20 from the new school. Yes, it's possible to do that. I think that you would actually have to attend the school if you're going to stay here and you want to eventually adjust status. In order to adjust status, you have to prove you've maintained your status the whole time you've been here and every prior time you've been here in the US. There are some exceptions, but the general rule is that you would have to maintain your status. So yes, you can go to another school. That doesn't permit you to kind of work on the EB2 NIW endeavor. And then as well, actually, transferring to a new school and getting a new I-20 is not a big issue. But if you wanted to then travel, getting a new F1 visa stamp at a consulate may be difficult if you have, an immigrant petition pending. Yes, it's possible, but could be complex. I'd say it's something where you want to kind of discuss with an attorney your specific situation to make sure you're planning the steps in the proper order and that international travel, concerns and things like that.
Absolutely. And what some people will do, Kelly was talking about dual intent visas. One of the most popular examples of that is the H-1B. So some people will go from an F1 to an H-1B, which does allow you to pursue a green card while you're on the H-1B. Would a professional plan or business plan be a better option for a foreign trained lawyer who wants to apply for an EB-2 NIW? I'm not sure of the difference between a professional plan or a business plan. Kelly, do you have thoughts on that?
Yeah, I'm not sure what this question is. Yeah, I'm not really sure what this question is asking. I think that, if you're going for an EB-2 NIW as an entrepreneur, a business plan, a comprehensive business plan is a very important part of that application.
Perfect. All right. Well, thank you all for the wonderful questions and for taking the time to join us for today's webinar. Kelly, thank you for sharing your expertise. Do keep an eye out, everyone, for that email, and we hope to see you on future webinars. Stay
Thank
well
you.
in the meantime.